the conclusion at page 17 of the synopsis of the investigation.
I'm going to object. We all know that portion not admissible. It's your second.
I'll overrule this. Go ahead.
It says, search efforts for the missing teenagers were unsuccessful and our investigation has exhausted any credible leads which might have helped locate Stephanos and Perry Cohen. We have been unable to find any further information as to the whereabouts of these missing teenagers. At this time, Tequesta Police Department has entered both Stephanos and Perry Cohen into the Florida Crime Information Center's database for missing persons. This will remain classified as a missing persons case until additional information is discovered. Now, importantly, Your Honor, this report was given to the families, but not given to the general public, because I think it's well known in Florida law that while an investigation is open, the reporting is not a public record and remains in the hands of law enforcement and interested parties if they feel like they need to supply that. This report was released yesterday or the day before, which is kind of confounding to the plaintiff because of just what I read, that this investigation is going to stop here until new information is found, and then in March, the boat that the boys were on at the time that they disappeared is found off Bermuda. The boat is collected by a Norwegian trade vessel. And so now we all have information and notice that there is a new field of evidence to investigate. So there's no cogent reason why the investigation would not continue when the report itself says it will if something else is found, and then something else is found, including the iPhone. And as I said in my pleading papers, Your Honor, and this is verified, the reasons for refusing to hold on to the phone when we talked to general counsel and when Pam and her husband talked to the actual investigating officer, Captain Artelin, was this is not a criminal investigation, so we can't hold the phone. During the course of the investigation, cooperation was asked of the parents of Perry. Consents were signed to waive absolutely everything related to any privacy concerns, search warrant concerns, cell phone data from historically the days leading up to it. But in this particular situation, when Captain Artelin called Pamela Cohen to advise her that the boat was found and that there was an iPhone, he told her that there was an iPhone. And her husband said to Captain Artelin, and again, if we need to get to a hearing, we can put both of them under oath, but I'm representing as an officer of the court, this is a fact, that Captain Artelin said, we're considering the iPhone personal property that needs the consent of the owner for us to investigate it further. And indicated that he was seeking the consent of Stephanos, the father. That's March 19th. Then, just coincidentally, last Friday, not that FWC gave the parents any notice that they intended to give the iPhone over to Mr. Stephanos, it was just by happenstance that Pamela Cohen contacted the FWC and asked about the status of the iPhone. That Captain Artelin again said, Mr. Stephanos has not come in with consent, and now he's demanding the phone. So we checked with our legal department, and we're going to be compelled to give it to them. That's what started this legal chapter with the filing of our motion at 1 a.m. in the morning on Saturday morning. So
Are you aware of any law enforcement agency that's expressed an interest in getting the iPhone or the contents of the iPhone out?
We have not reached out to any law enforcement agency about that issue, and I must say, Your Honor, that we recognize that generally speaking, we cannot question or challenge the discretionary acts of law enforcement and the decisions that they make. Do they have interest or don't they have interest in a particular investigation? But in this case, Your Honor, we can't help to assume that the FWC has essentially abandoned their responsibilities because of all of these inconsistent statements. It is a criminal investigation. We will continue it when we get more evidence. And then that precise circumstance arises, and it seems like the department is bending over backwards to abdicate what it said in a lawful document. The investigation is an official record. They seem to reverse course when there's more evidence to investigate. And what's even more inconsistent about that, Your Honor, is when we spoke to General Counsel, and it's been publicly discussed in statements by FWC, they intend, when that boat gets to Port Everglades on May the 16th, they intend to take that into custody and investigate the boat. So if the investigation is over or it's not criminal, why would they be doing that? It would seem logical that the owner of the boat, which is in slack, would simply be able to say, it's my boat, I want the boat, and you can't investigate it. The boat, which is not an issue today, Your Honor, the phone, is the very first piece of physical evidence from the boys since they went missing. It potentially holds the key to answer questions that a mother desperately needs answered. And let's not forget, Your Honor, that the boys are not declared dead. We are all making presumptions about that issue. But we've also heard the 1 in a million chance that they're not. And a mother has the right, the legal right, to exhaust all of her legal possibilities to seek information about what happened to them. And so, with regard to this particular motion, Your Honor, it is Ms. Cohen's position that having filed a lawsuit, having given notice to FWC while the phone was in its possession, having personally, myself, spoken to Mr. Gillauer on Monday morning after we filed the lawsuit, and given assurances that if that agency intended to give it back, that we would be given some notice so that we could prepare and adjust and perhaps seek court intervention. No notice, no courtesy was given to us, and when I spoke to Mr. Gillauer on Tuesday afternoon, before it was handed over, I'm under the assumption because we've never actually, even to this moment, been given official notice that it was handed over. We learned it from the press. On Tuesday afternoon, when I gave a courtesy call to Mr. Gillauer to tell him what the status of the case was and to let him know that we had a hearing on Thursday, which was coordinated through Your Honor's judicial assistant, he told me, I asked him, what's the status of the phone? And the answer was, I don't know. I don't have very good communication with my leadership in South Florida, and I have other cases too. And Your Honor, that, I'm sure, is all true. But when an action is commenced, and a court does have at least ostensible jurisdiction over the parties, and they've been served, I think that there is an obligation on the officers of the court and the parties to act with due respect to the court's authority. And I think that that was usurped in this case, and that is the reason that we filed the emergency motion And I do believe that this court can undo, has the authority and the power to undo what was done to protect the contents of the phone and to protect the integrity of those confidential communications of my client with her son.
All right, and specifically, what are you asking the court to do?
Specifically asking the court to take such means as are necessary to have the court take custody either directly or through a third-party friend of the court for safekeeping of the phone until these issues are sorted out and they've been briefed and proper notice has been given to all parties.
All right, thank you. Yes, sir, Mr.
Wait,
Mike.
do you mind if I stand?
That's fine.
Couple of things, Your Honor. Plaintiff filed its or her ex parte motion. And Mr. Rubin discusses a lot of facts, but there is not one case supporting his request in his motion. Matter of fact, there are two motions, and in neither motion is there one legal case that supports the proposition that this court can take an iPhone that belongs to Mr. Stephanos and preserve it. First, let me tell you this. My client is preserving the phone and is going to take every means necessary to have that phone forensically analyzed. This court does not have jurisdiction of this matter. You heard Mr. Rubin say he admits that his client does not own the iPhone. And if the court will address the following. In Munoz versus the City of Coral Gables, 695 Southern 2nd, 1283, Florida 3rd DCA 1997, the 3rd District held that at an adversarial preliminary hearing under a forfeiture statute, the party opposing seizure must establish some possessory or ownership interest in the property in order to establish standing to contest probable cause. There has not been any possessory interest established in the motion or by Mr. Rubin through his testimony and through the hearsay testimony of a bearish report. Moreover, what's even more compelling is the fact that Mr. Rubin will not tell you that there is an ongoing criminal investigation or that there is an ongoing investigation by any authority, because there's not. My understanding as PBSO, Palm Beach County Sheriff's Department, has not commenced an investigation and or has closed its investigation. FWC was the party investigating the matter. Clearly, FWC has closed its investigation, and therefore there is no open investigation. Which brings me to Article 2, Section 3 of the Florida Constitution. And it says, under this doctrine, the judicial branch must not interfere with the discretionary functions of the legislative or the executive branches of government absent a violation of a constitutional or statutory right. Mr. Rubin has not met the standard for this court to take any action because he has admitted he has no possessory or ownership interest in the phone, and there has been no violation of any constitutional or statutory rights.
I understand this felon's claiming a right to the information on the phone, and that there was notice that the phone should be preserved, or her intent and request to preserve the phone, preserve the information on the phone, and before there could be a hearing, it was turned over to Mr. Stephanos.
That was something that FWC did, which brings me to another case, Your Honor, that I cite in my response motion. And it's titled on page Paragraph 12 of the response motion, it's titled, "It is impossible to undo what has been done." And that is in the case of Fredericks versus Blake, 382, Southern 2nd, 368, Florida 3rd DCA 1980. The court found that an injunction will not lie only to restrain commission of a future injury, since it is impossible to prevent what has already occurred. FWC turned over the phone to the owner, my client. Injunction is not the appropriate vehicle in this matter. Not only is it a violation of the executive branch, and the judicial branch cannot get in the way of the executive branch, but in this case, my client will be preserving the phone and sending it to a high-end forensic analyst, and that forensic analyst will be Apple. Apple has already agreed to take in the phone and forensically analyze it. Your Honor, may I approach?
Yes.
I'm going to show you some photos of the phone itself. And I don't believe these photos have gone public just yet. But if you look, the phone does not have a case on it. The phone is substantially damaged, and it did not have what you would call an OtterBox or a life-proof case. It is cracked, it is open, the face is peeling off of it, it has substantial water damage. The gloves that you see in the picture are those of an investigator or an employee of FWC. My client, Mr. Stephanos, has the same interest in preserving this phone and the contents of it. However, this court does not have jurisdiction in this matter to enter an injunction from the outset. The verified amended complaint in the wherefore clause of counts 1 and 2, and I'll take you to those allegations. Page 5 of the verified amended complaint states that on paragraph 29, plaintiff seeks emergency preliminary injunctive relief against defendant FWC, prohibiting the agency of the state of Florida from delivering Austin's iPhone to Carly Black and Blue Stephanos under these circumstances, etc. Paragraph 25. I'm going backwards, Your Honor, I apologize. FWC has no apparent interest in continuing its investigation into plaintiff's missing son, despite its duty to consider additional evidence as it becomes known and available to consider, and to reopen its investigation to enable the investigation to be completed. Count 1, right under paragraph 47, the wherefore clause. Wherefore, plaintiff respectfully requests that this court issue a declaration determining the iPhone in IWC's custody be retained by FWC or an appropriate law enforcement agency for further investigation. Count 2, plaintiff respectfully requests that this court enter a preliminary and permanent injunction, which I'll get to because now we're treading into a mandatory affirmative act. We're no longer in this complaint seeking a preliminary injunction. Now we're seeking a mandatory injunction, which is quite different because a preliminary injunction prevents something from occurring, whereas a mandatory injunction, both of which are extremely extraordinary, okay? Mandatory injunction is affirmative act to require my client, who has a possessory and ownership interest in the iPhone, to turn it over to someone under what law, under what basis. Finish with the wherefore clause. Wherefore, plaintiff respectfully requests that this court enter a preliminary and permanent injunction requiring the FWC to retain the subject iPhone until it can be submitted to the appropriate law enforcement agency and analyzed for evidentiary value. Furthermore, Plaintiff requests that all further recovered property from Austin's boat be retained by FWC or turned over to an appropriate law enforcement agency for further investigation of the open missing persons case of Austin and Perry. Counsel just admitted that there is not an open investigation by FWC. There is not an open investigation by an authoritative body. In addition, Your Honor, with regard to procedural due process today, courts have held under Anderson versus SunTrust Bank, 679 Southern 2nd 307, Florida 5th DCA 1996, that 4 days notice of a hearing is not sufficient for an award of guardianship fees and costs. Similar here, 4 days notice of this type of hearing, which was not set for evidentiary pursuant to Your Honor's order, but was requested evidentiary pursuant to the ex parte motion, is insufficient procedural due process for my client to prepare for same. Having said that, the issue in this case that strips the court of jurisdiction to rule on this matter is the fact that there is not an existing lawsuit requiring or requesting relief against Mr. Stephanos. The relief does not state a cause of action against Mr. Stephanos. And the courts are very clear in that regard relative to injunctions. In Cadillac Plastic Group versus Barnett Bank of Martin County, 1991, Florida 4th DCA, the court said the issue is whether an injunction may be entered upon motion where no complaint or similar initial pleading has been filed. Also citing International Village Association versus Shafi, 786 Southern 2nd 656, 4th DCA 2011. Allowing a preliminary injunction to issue in the absence of a pending request for ultimate relief would be contrary to the purpose of temporary injunctions, which essential requirement would be rendered meaningless, Your Honor, if, as here, as in the instant case, the petition for temporary injunction was filed when there was no pending action. There is no pending action for injunctive relief against Mr. Stephanos. And therefore, this court cannot rule today as to any injunction, mandatory or otherwise. Finally, Your Honor, in American Fire and Casualty Company, it's an interesting case where a taxi cab owner sought temporary injunction to prevent the canceling of his own insurance policy. The court there ruled that a mandatory injunction, which is apparently what they're seeking despite the fact that the complaint in and of itself does not properly plead a mandatory injunction, says that a mandatory injunction will not be granted unless the complaint alleges definitively every fact necessary for relief. The court, in making its ruling, found that it was not advised whether or not the insurance commissioner in that case had approved a particular plan, and that the complaint did not allege those facts clearly. Here, there are not any facts alleged against Mr. Stephanos relative to injunctive relief, and therefore the court does not have jurisdiction to make a ruling on the matter. However, I want to be clear with the court. My client's intent is to send this phone to the best analysts, in my opinion, in the world, the people that created the iPhone. And Mr. Rubin said it was an iPhone 5, but it was an iPhone 6. And the iPhone 6 is going to be sent to Apple. We have a consent form that I can show Your Honor. And I'd like to keep this.
All right, do you want these back, by the way?
We have a consent form that I'm handing Your Honor that will allow Apple, the manufacturers of the phone, to forensically investigate the phone and determine if at all possible, whether or not any information can be retrieved. And my client, and I want to be careful because I do not want to stipulate to jurisdiction of the court here, but my client will agree to share the information that is relevant to the boys going missing. My clients have no intention of spoiling or destroying any of that information. What my clients want to do is preserve their son's phone, send it to Apple, and we will share the information that is relevant to this case. Obviously not his son's personal messages to his friends, but if those personal messages may have been sent during the period in time when they were on the boat, my client does not object to sharing that information with Perry's mother. With that, Your Honor, we ask that you deny their motion.
Let me ask this, is there any prejudice to Mr. Stephanos or harm if the evidence, his phone is preserved and nothing's done with it until we have more of a full hearing on your motion to dismiss, on their motion for relief?
Yes. My client was going to be on a plane today at 10:30 a.m. flying that phone out to California. As you know, with salt water and saltwater air, the longer that phone sits, the longer it's going to continue to deteriorate. That phone has been submerged in the sea. That phone needs to be sent to Apple as soon as possible for preservation. Not to some small business here in Florida, not to some third party in some other state, but to Apple. We will be sending the phone to Apple because we do not believe under the law that the court has any jurisdiction in this matter. And our obligation is to preserve, not to turn over. Spoliation is different than possessory. Our obligation is to preserve, which is what we are going to do by sending it to the manufacturer of the company. So yes, not only would my client be prejudiced because he wants to have the information on the phone, maybe the last messages his son sent, maybe the last messages her son sent, but allowing the phone to sit pending an order from this court is going to prejudice both families. And with that, we ask that you deny their motion.
Mr. Vielhauer, anything you want to say?
Your Honor, one thing is I'm a little disappointed in Mr. Rubin's misrepresentations of our conversations and some of the name calling that he put forth in his motions. But if it would be helpful, I can give you the nature of the background of the investigation that we conducted. Again, the bottom line is that we do not have the phone and we are no longer a party to this. I think just to help out, it is important to point out that truly this was never a criminal investigation. It started out and has always remained a boating accident investigation, missing persons report. I think it's helpful too to note that we had initially attempted to get a search warrant for phone records, which was denied by a court in your circuit, by a judge in your circuit. We also approached the state attorney's office after we got a hold of the phone, and as was pointed out, the phone was significantly and severely deteriorated when we came into our possession, but we did make contact with the state attorney's office and asked if it would be possible to get a warrant to get the contents of the phone, and we were told at that time that, again, since there is no probable cause that a crime had been committed, we could not get a search warrant. So with that, at that point, we're in a position of we're holding on to somebody else's personal property that we had no right to hold on to. And once there was a request for that phone, we returned the phone to its rightful owner.
All right. It was suggested that the Florida Fish and Wildlife Conservation Commission may be looking to investigate the boat or other contents when they come to Fort Lauderdale.
We will do that. Once the boat comes back in, we will take a look at the boat to the extent that we can. I mean, we might have some potential issues in getting into any locked or closed areas if those occur, again, for privacy issues. But we are going to go take a look at the boat and try to see if there's anything additional that would be helpful. So
there is an open investigation?
Well, no, technically there is not an open investigation. I mean, well, technically a missing persons case is always and will always remain open. But there is no open criminal investigation. If anything does come up and might be useful when we see the boat, we will note that in our report and try to investigate it further. But at this point, we have nothing to suggest that this was not anything more than just an unfortunate and accident.
All right. And the Florida Fish and Wildlife Conservation Commission's looked into it and is not interested in trying to investigate information or obtain information from the iPhone?
We can't. Not unless and until something comes back to us that suggests that there's something helpful on it. And there have been some representations even here today that once Mr. Stephanos has it analyzed, that he will provide that information to us and we can add that to our report and to our investigation. But at this point, we have nothing else to go on and until we actually see the boat or see the phone, get the results from the phone surveys or investigation.
All right. Anything else, Mr. Rubin?
Yes. The last thing that I heard is that they have nothing new suggesting that there's any change from what the original presumptions were that the boys went missing or what caused their disappearance. And that's simply not true, Your Honor. Photographs were provided by FWC to the families. One of those photographs, and I'm not sure that I have it, but I can certainly pull it up and show you, Your Honor. One of the photographs shows that the the battery indicator was turned to the off position. And the significance of that, Your Honor, is that in an outboard motored boat, when an indicator is turned to the off position, first of all, that's not the kind of thing that can turn by wave action or over time. It's intentionally the kind of switch that takes force of wrist action to turn into an off position. The fact that that battery indicator is in the off position now, when the boat is found, has an implication.
Judge,
And that,
I'm going to object again. This is not an expert. This is speculation. It's hearsay, and he is testifying as a witness.
And for what it's worth, Your Honor, we did run that issue past our boating investigators, and they have said that what Mr. Rubin just said is actually untrue. That wave action, they have seen wave action and other environmental conditions turn that switch into an off position before. In addition to that, the boat has been now handled by several folks who could have potentially had some impact on turning off that switch also. In addition to the folks on the Norwegian freighter who actually rescued the boat or recovered the boat, there was another sailboat who had made in contact with the boat a couple months before that. We had contacted, or when they contacted us about it, we asked them if they could help try to recover the boat and put it on to their vessel. They got into the other boat, tried to right it, tried to bring it back, but they were unable to actually recover it, and they could have actually turned the switch. There's several reasons why that switch could have been turned off.
All right, allow Mr. Rubin to conclude or finish his
yes, Your Honor. All of this is exactly why we need to let science take the day. We have the FWC saying we don't know why something might have happened. this is adding conjecture and speculation into a matter of law enforcement where we actually have methods and practices of forensic examination to determine these things. And essentially, what I hear is the FWC is simply saying, we don't think that there's anything that can come from the boat or the iPhone, so we just don't want to have anything to do with it anymore. That's what I hear. And I don't think that this public agency that spent millions of dollars in an investigation along with the Coast Guard should be jumping to conclusions instead of using scientific method to make these determinations.
Well, for purposes of today, though, we're here with the iPhone and what we should do with the iPhone and the contents. And I don't believe I have authority to force Florida Fish and Wildlife Conservation Commission to do anything. So, as to the iPhone, is there an objection to Apple doing a forensic evaluation?
We don't have any objection to, and what we asked FWC when the phone was in their possession was for them to put it in the hands of an expert like Apple, and all they had to do was to take that same action, but Lou Stephanos refused to sign a consent so that that phone could stay in chain of custody. Now, Mr. Stephanos comes into court and represents that his intentions are to do this, and his intentions are to do that and to share information. But those intentions are only made and essentially a promise without any enforcement is being made to the court, because if he changes his intentions, there's no repercussions to that. That's precisely why we went to the FWC when it was in their possession, so that we could make sure that law enforcement had this evidence, secured it, kept it in a chain of custody, and preserved it the proper way. The whole thing could have been avoided by Lou Stephanos simply giving consent when he was asked to do so.
We're here now.
Right, exactly. So this court does have authority over a party to this case, was served with this action, and can issue orders to any party in this case to comply with the court order. And we believe that the court does have jurisdiction to preserve this particular phone. And whether we call it a motion for injunction, or actually when it was originally filed, we had it titled a motion for pure bill of discovery, which is a recognized cause of action in the state of Florida, which gives the court authority to issue orders with regard to these kinds of things, even without a complaint being filed and even without relief being asked.
What about Mr. Stephanos' argument that the only relief being requested in any of the pleadings, including this motion, is directed to Florida Fish and Wildlife Conservation Commission? You're asking me to have them do something.
Well, at this point, I agree that nothing can be done with regard to FWC, but we've had a change of circumstances in the last 24 hours, Your Honor. So, I mean, this court can entertain, and I'll officially make a motion to amend the complaint and the emergency relief to simply allege what we're requesting. Your Honor holds the equitable powers of the court to effect justice in these circumstances. And in these circumstances, when we filed our pleadings, the parties were in a certain position, and only because they changed their position in 4 days can they now argue that there's somehow nothing that can be done. That just is not equitable, and this court does have the power to correct that wrong.
Briefly, Your Honor.
Yes.
When the FBI needed to access an iPhone, who did they call? Apple. My client is going to be sending the iPhone 6 to Apple. My client will share the contents that are relevant to this case with the Cohens. My client's heart bleeds for his son and for their family. But the minute, every day that passes by, that phone is continuing to deteriorate. I am the one that made sure that my client did not get on a plane this morning and attended this hearing. But after this hearing, because I do not think the court has jurisdiction to enter an order, my client is going to take that phone to Apple. What I hear is Mr. Rubin argue that FWC did something wrong. But at the same time, I hear him saying that FWC does not have an open investigation, which FWC has confirmed here today. Mr. Rubin has confirmed and admitted that his client doesn't have a possessory interest in the phone, and she certainly does not have an interest in the contents of the phone because it is not her property. The mere sending of a forensic message does not constitute ownership to someone else. If anybody, the privacy belongs to Austin and his parents as the minor. Those are who the privacy rights belong to. In addition, and I'm concluding, a court may not order an executive department to spend funds when a statute or constitution authorizes the court to do so. Courts, however, have rejected the idea that there is a doctrine of inherent judicial power. This is why Mr. Rubin is wrong. Courts have rejected the idea that there is a doctrine of inherent judicial power that allows a court to direct how an executive department exercises its discretion to spend funds appropriated to the department. Same thing here. This court does not have the inherent judicial power to require FWC to do something at all. The case has been closed. There was never a true criminal proceeding open. I really do not understand why we're here because my client is agreeing to send the phone to Apple. We ask that you deny the motion, Your Honor.
Does Ms. Black want to be heard?
Your Honor, most of the issues, George Harris representing Ms. Black, most of the issues have been brought forth by counsel. Just as context to the court, the plaintiff's lawsuit in the context of his argument today is that he expects the parents of Austin not to do the right thing and to have this phone examined by Apple. I think the court is aware, and this is all based upon what plaintiff alleges to be an investigation or an ongoing criminal investigation or administrative investigation by the state, by some state agency. And I think that the FWC counsel has told us that that is not the case. Although it is a much smaller matter than what we've been talking about today, I'm not sure why my client, Mrs. Black, is even a party to this lawsuit because she does not own the iPhone. She has no ownership interest in the iPhone. She and Blue, Stephanos, defendant, have been divorced for almost 10 years. They have come together in grief over this case.
I'm not hearing, I don't know that there's a disagreement with Apple evaluating the phone, getting what information they can out of the phone. I'm not hearing that that's perhaps not the best place in the world or an inappropriate place to evaluate whatever information's in the phone. I believe the concern is that, or Ms. Cohen is looking for some sort of a court order or a private agreement that confirms that's what will be done. And I know Mr. Stephanos is making representations. He'll share the information or information relevant to Perry Cohen or his communications or what was happening in the boat when they were there together. And I imagine that would be agreeable to Mrs. Cohen, but is looking for some sort of a written agreement or court order that preserves that right. So the last thing I want to do is get in the way of having the phone evaluated by Apple, and that's not in front of me today. It sounds like the parties are fairly well in agreement what you want to do and what you're agreeable to doing. But the only legal issue in front of me today is whether I can enter an order that preserves the phone and the information in the phone until we have further hearings, or until we have further consideration of these issues, or until there's some agreement of the parties to do otherwise. While I am mindful of the three branches of government, and I'm not going to interfere with the executive branch and their operations, I'm not being asked to order Florida Fish and Wildlife Conservation Commission to do anything, and I'm not ordering that. And I understand Mr. Stephanos' argument that the pleadings as they are right now do not request relief against him as the holder of the phone. The relief requested is against Florida Fish and Wildlife Conservation Commission. However, there's a motion to amend those pleadings. There was this emergency, ex parte emergency motion for an order or an injunction to preserve evidence. And obviously it was filed as an ex parte emergency motion, ex parte meaning without a hearing, and without advising Mr. Stephanos for me to enter an order to preserve the evidence. I thought on relatively short notice we could come in and address these issues which you have. I understand that for longer, more involved hearing, more substantive hearings, you would need time to do research, and we've reserved, I think it's next week sometime. I think the law does allow me to enter an order to preserve the evidence until we can have a longer hearing. I think the law allows me to preserve the phone or the contents of the phone, that they not be accessed or tampered with until a full hearing when the rights of Ms. Cohen to the contents of the phone, as they're requesting, can be addressed. So I think I can and would enter an order that I have jurisdiction to preserve the phone and the evidence, but encourage the parties to agree to at least get the phone to Apple, get the phone evaluated by who you agree are the experts who should do that. If you need to come back for a hearing on what information or what we've done when the information comes out of there, we can have a separate hearing on that. If you can't reach an agreement, I can look at documents in camera and decide what Ms. Cohen may or may not have access to and argue about that. But I think I've not been asked to, and I don't know that I have the authority to order the parties to send the phone to Apple today or tomorrow.
Actually, Your Honor, you have taken authority that, in my legal opinion, is outside of your jurisdiction.
I understand.
However, if you are going to enter an order preserving the phone, you have authority to tell the parties where that phone should be sent to preserve. We don't know what is on that phone because it is rusted and corroded. So the longer we wait, the court, through its order of preservation, is going to cause further damage to the phone.
Well, and that's why I encourage the parties to agree if I'm entering an order of preservation. But if the parties agree I can enter an order that allows it to go to Apple to be evaluated, and there's no disagreement about that, I'm happy to do it, that the phone... And I understand that you don't agree with me taking jurisdiction to do anything. I understand that. But I believe I do to at least preserve the evidence until a hearing on a motion to dismiss, a motion to amend, all of those motions. But I'll be happy to enter an order that the phone be expeditiously taken to Apple, and Mr. Stephanos can do it if he wants to go out there and do it, that he retains custody of the phone to make the transaction, to take it there, to get it evaluated. I have no problem with that at all.
My client will take the phone to Apple as fast as he can get planted it and drop it off to Apple.
All right, Ms. Cohen.
Yes, Your Honor. As much as we appreciate the fact that they want to do that, this court cannot monitor, order, or control any of that. If we have an agreement, which we're happy to have discussions about, And if there's a stipulation that this court does have authority, because if there's this argument about lack of jurisdiction and authority, then I don't think that they're going to give you the authority to sign an order which stipulates how something should be done. But all we have asked for since the existence of the iPhone has been known was the consent of Lou Stephanos, and all we've been looking for is information unfiltered by someone else. So I would ask Your Honor to enter the order that you suggested. We're happy to meet with them, and I'm happy to come back on Monday, hopefully with an order for Your Honor to approve so that we can have an accountable method to take this phone and preserve it and get the information. I think that serves all of the interests.
When I asked you earlier, I understood that Ms. Cohen had no objections to the phone going to Apple and being evaluated there.
Oh, no, we don't object to that, the concept of that, but we do have an objection to having a party simply get on a plane with that phone and trust that person to do the things that they're saying they can do without having it reduced to a writing. I think that's what Your Honor was suggesting.
My understanding, right, I mean, what's your recommendation of how the phone would get out there and be evaluated by Apple?
Evidence is always Federal
Let me
Express. We can Federal Express it there. It doesn't matter.
Is that your
to us.
preference?
I'd like to have a couple of minutes.
Do you want to take a break and then come back?
Sure.
And unless you can agree otherwise, on the larger scope of what you want to do with the information. But it seems to me, I mean, a court order just getting the phone to Apple as soon as possible. For that, if that's all the limited purpose you can agree on today, then at least get that done and get that started. And if it's Federal Express, I don't, whatever the parties agree to, how the phone gets there, it's fine with me.
The phone needs to be sent on.
So if you want to take a minute or two, take a break, to talk about what you'd agree to or what, yes, sir.
Just because this would be considered something that would be appealable. If we don't reach an agreement, it's just going to take longer and longer. So we want the phone, my client wants the phone sent to Apple as soon as possible. How it gets there, we don't care. The court can enter an order saying Federal Express it to the person on the consent form here.
May I have 5 minutes with my client?
All right, we'll take a break. I don't know if you have an order for today. We have blank orders, whatever language you all can agree to. All right, we'll be in recess for 5 minutes, or just let the deputy know when you're ready to reconvene.
Looks like the legal enemy, so go ahead and take the jury room. Grimsley, I opened some conference rooms outside. What we're going to do, we're going to step over. Jury room, then you have some privacy. You take it. That's okay. That's it. Now, then you guys have some photos. remain seated. Court's back in session.
Judge, we've come to an agreement. We've drafted an order. I'll read the order for the record. However, I've left the granting or denying for yourself. I don't know whether or not it's going to be denied or in part or how you're going to word that.
All right.
But it basically says, ordered and adjudged that said motion be and the same is hereby granted, denied. The court orders that the iPhone 6 be sent to Apple Inc. by William B. Stephanos by Federal Express overnight delivery. The Cohens shall be kept up to date as to the progress of the forensic analysis by Apple Inc. and Blue Stephanos consents to same. Blue Stephanos shall provide the Cohens, should be singular, with a tracking number for the Federal Express package. Any forensic report and/or data recovered shall be sent to the court for in-camera inspection and shall remain under seal at the discretion of the court. Production of information or data to Cohen shall be determined by the judge based upon the relevancy to Perry Cohen and Austin Stephanos' disappearance.
All right. Anything else?
May I approach, Your Honor?
You may. Do we want to style this as an order on the verified ex parte emergency motion or just an order to court? Not tied to any specific motion?
Well, I think it should be on plaintiff's motion, which was,
All right.
I don't want to be misconstrued as it was an ex parte for the record, because it wasn't.
I know.
Yeah.
That's the caption. I can put the cause came before the court on plaintiff's verified ex parte emergency motion for order/injunction. And without granting or denying, I'm simply ordering it to this relief.
Agreed.
That's all. All right. How do you want to handle, so that whatever results of the investigation, whatever can be obtained, they're going to send to me?
That's the intent, Your Honor. I'm sorry, Your Honor?
Whatever comes out of the investigation, that will send it directly to me?
Correct.
How are you going to do that? You're going to give them a FedEx envelope, my address, to come back?
We will send the appropriate information and CC counsel on that letter.
All right. And then they'll let you know.
If there is a forensic report to be gleaned from their analysis.
And if they send me something, they'll let you know it's being sent.
Yes.
Hopefully, and then we'll all know that it's arrived, and we'll set a hearing if we need it to evaluate whatever they think. Hopefully they think so.
And it's not in there, but I think we have an agreement that FedEx will go out today, by overnight.
He has the address. He will make the contact today. and it will be FedEx today.
Bring me some copies for you. I'll be right back.
Remain seated. I was going to remind you, I usually get a lot of Remain seated. We're back in session. It's all the same thing. Yeah. Did I miss anyone?
Anything else we need to take up today?
No, Your Honor.
No, Your Honor. And you have hearing time reserved for next week. Do we need that?
I don't think we need it at this point, so we can take that off the calendar, and if we have anything else to bring to the court's attention, we can just do that in due course.
All right. Anything else, Mr. Vielhauer?
No, I have nothing further, Your Honor.
All right. I appreciate you all talking and cooperating, and good luck. Hopefully you find some results.
Thank you, Judge. Thank you.
All right, thanks. We'll be in recess.
Expecting something to be done.
Yeah, we're gonna let them on. We'll try to. But we still have to go to the elevator. If I want to go this way. Sure. Yeah. All right. Well, you can roll that.
I know.
Thank you.
That's smart. You need a rolling one. Thank you. Well, we hear,